Hello people, welcome again. A little video on my little rabbit hole excursion down to the grand juries and juries in general. It's a bit complicated, this whole journey, if you like, because I'm comparing. It's nice to use the American system as a cross-reference to what's actually happened in England, because all the nonsense that happened in England is essentially what led up to a load of people in America deciding enough is enough. We're going to have our own system of government, independent of this crown and parliament. And it's those early Englishmen, if you like, who decided to break their ties to their homeland, which is which is in no way a small decision to make. Great threat to their lives, but yet they obviously felt strongly enough about the injustice, if you like, that they felt it was worth doing. So that's why the American independence, or what it was an English independence that led to being America. That whole thing is a really good kind of bookmark in history to say, right, what did the founders of America, the Englishmen who founded America as an independent nation to become and then eventually created the United States of America as a government, what did they think was important to them, things that were being omitted or oppressed from the justice system that they were used to, and how has that naturally evolved in England since that independence, so that we can get an idea of how this grand jury, dare I say nonsense, carries on through the criminal justice system and the court system as a whole. Now this is a big question and it involves a lot of details, but what I've just found here is a nice little video from New York's city-state, which is one of the states that in recent years has been, they've been quite staunch in some of the applications of the Constitution in a lot of their judicial decisions, which has been great to see, because you want the judiciary to be a barrier from oppressive legislation, oppressive legal corporations or companies or people with new ideas how to swindle or gain money. The idea is that the judiciary is a form of defence, but it's not foolproof, unfortunately. There's influences put upon the judiciary, and the judiciary is quite often paid by the state, and the state has its own influences in relation to tax collection and administration of a orderly society. So where does that link into the grand jury? Now, the way that I look at grand juries now, and I'm becoming increasingly convinced of this, is that grand jury is really a legal kind of safeguard against criminal charges against the population. So basically, if someone's being accused of something, treason, murder, robbery, arson, whatever you want to pick a lovely crime, the idea is the grand jury is like a safeguard, and the petit jury, the 12-man jury, the grand jury being a 25-man jury, or 24 or 23, whichever way you want to look at it. So the grand jury is the first point at which regular folk, ordinary people, can see what comes before them, scrutinise it in privacy, away from an open court setting. It comes before the grand jury in privacy, so that no one, whatever happens in that small little room, it's not for the public, it's for strictly private with the 23, 24, 25 people of the grand jury, just to sit there, listen, take in, and then they put their hand up whether they think it's a true bill, or if the indictment should be given or the indictment should not be given. And that's essentially it. So that's a nice, quiet, non-public or private, you might say, way of getting rid of the charge, whether it be frivolous or it's just not frivolous but there's not enough evidence, and so going to trial will just be a big embarrassment to all involved. But it's a fantastic service to do that. Now, let's say it is indicted and the person has, and obviously everyone in that 25-man grand jury has a duty to ensure that they have to spot when suspicious things, suspicious prosecutions, unfair prosecutions, or things that have a certain amount of bias coming to them or influence. They're there to use their judgment and their moral compass, which we all have inside us, to decide, you know what, this sounds great, it sounds fantastic, but something inside me says I shouldn't agree to this. And that's your moral compass. Okay, so when you're moral, or it might say something inside me says that this should go ahead. Whichever way, it doesn't matter. I'm not using any case in any particular example here, but just to stick with your moral gut feeling. What does your feeling tell you? What does your brain tell you? The facts, and what does your gut make of all of that? Because you've got to live with your decisions. Okay, you don't want to put innocent people in prison, and you don't want to let the guilty run free, do you? So that's basically how that works. And then the grand jury turns into a trial jury or petit jury, 12-man jury, and the 12-man jury then is the final stopper to see whether or not the accused is obviously going to pay the biggest price of all, to pay the debt, because reclaiming monetary values in criminal courts isn't really something that's done. You get the debt essentially is paid for with your time in prison. That's the idea. You go to like it's essentially a debtor's prison. You know, you're denied your freedom in order to protect society from your actions, and also the time spent is your debt being repaid to society for your wrongdoing. It's a penal, it's a condign punishment. It's a penal thing. And that's essentially it. So I love this. This is a bit of propaganda from, well, sorry, not propaganda. This is a bit of marketing, a slim definition between the two. But this is a bit of marketing, and I found it quite interesting. The presentation of it about the state of New York and what they're trying to tell us about the grand jury service versus what's going on. So that's for the state of New York and how they're viewing at it, and then essentially how it's been changed and amended in England. And I'm just going to pick up on the American features that are no longer prevalent in England, and we're going to look at some of the reasons why that may or may not be a good thing, in a reasonably unbiased way. But obviously, grand juries are just one element of the criminal law, but they also extend into civil law. And in civil law in England, well, that's a video for another time as to relation where juries have gone from that arena. But let's start in with this lovely lady.
Welcome to the democratic process. Your call to jury duty may be the most important civic role you perform outside of a voting booth as a participant in this great democracy.
So, civic duty, so civic being civil Roman law, okay, not necessarily the common law, it's a civic duty. Civic and civil and Roman law, they all fall into each other. So this is not necessarily, she's not talking about the law or customs of the land, but she does mention that in a minute. Outside of voting, so once you're like a citizen and you have to vote to elect your leader of your body politic, your corporate body politic, the United States of America. That's about being an active participant as a citizen within the running of the state, as it might be here, or it might even be in the broader sense, the entire government.
Here in New York, with our system of checks and balances, it's the responsibility of the state, as represented by the prosecution.
It's the responsibility of the state. So the state, and this is a word I've been looking at, and Carl Lentz has explained the word state is a bit of an everything word. I mean, there's all kinds of state and all kinds of uses for the word state, and there's some on your screen right now. And I also like to go into the free legal dictionary online. It has quite a nice, every word here you can touch, you can press on, and it's like, well, not quite sure what the word territory means, so I can press that and it'll just right, boom, this is what we reckon territory. So it's fantastic for like going reading through and trying to occupy, what does occupying mean? And it says, oh, see, situated, and what does situated mean? Goes through. It's a fantastic resource. But state, so the dictionary definition here has quite a few listed out. So there's all kinds of things. So it also mentions, you've got mental state, emotional state, you've got a state of being, solids, liquids and gases. You've got the supreme public power within a sovereign political entity. So there's all kinds of the sphere of supreme civil power within a given polity. And then you've got a specific kind of government, all kinds of body politics. That's normally a corporation when you enter into the body politic of a corporation, especially one constituting a nation. So there's all kinds of states, and as you can see here, this is just a dictionary definition. Okay, this is not necessarily the legal definitions here. And also, you got, look, there's 21 here. That's the word state. So in what form is she referring to the state? Now, obviously, in the state of New York, you'd probably be inclined to think of the state of New York and the administration. And here's the legal definition, which you can read at your leisure. But yeah, I mean, this goes into a lot of detail, which I haven't got time to go through. But basically, just look at the word state. When she says it's the state, and it's being brought on behalf by the prosecution, which is like, that's a big thing. So the thing, essentially, the body politic, the corporation, is bringing the prosecution via not really an attorney, because I don't think a state can attorn. It would be a representative, I suppose. I suppose the state could attorn if you've got an agent that has the power granted to the like the head agent of the, like, so for example, the United States of America. The United States of America, its top agent is Donald Trump. In theory, I'm not privy to who is the actual top agent, but you know, the president of the United States would be the top agent, and that top agent might be able to subcontract to other agents that now become an agent of the agent to the principal, which would be the United States of America and whoever owns that. Okay, so I know it's a little bit complicated, but this is how it all works. So yeah, she's talking about the state bringing charges against people or citizens, presumably. Actually, citizens would be probably more accurate, and other people doing their civic duty to do their jury service in order to prosecute on behalf of the state against the allegations that is being brought by the state in the form of a public prosecutor of some sort.
To present the evidence against any person accused of a criminal act.
Any person. And remember, in America, it was recently, I saw on, I wouldn't say recently, maybe about a year ago, but there was actually a White House debrief where one of the guys actually admitted to the press that person, as far as the United States, can mean living or non-living entities. It can be a corporation like Coca-Cola, or it can be, you know, Dave Fitzpatrick down the street who's a farmer. You know, the person is a catch-all tool. It's a tool to catch all kinds of persons into the system that they wish to bring this criminal justice system to.
It's the duty of a grand jury, you people sitting here today.
As she even said it there, it's the duty of a grand jury, you people sitting here today,
to review that evidence and determine whether that accusation is legally justified.
Legally justified. Now that's an interesting question, right? She's talking about you people. You know, people just being like Joe Bloggs on the street, the layman, the John Doe, right? And now they're trying to say, but you have to decide whether that accusation is legally justified, and you people aren't legally qualified members of the legal society. What's your criminal training, your criminal expertise? How are you people going to make a legal determination of legal charges?
As grand jurors, your decisions must be based on the evidence and the law. And as you serve, always remember that our grand jury system is designed to help protect the rights of citizens and uphold the laws of the land.
There, she said it. So protect the citizen, yeah? So she's saying it's protecting our own people. Sorry, not our own people, not necessarily protecting the people, but protecting our own citizens from our own charges. That's quite an important distinction. It's about the citizenry being held to it. It's like well, she's using people and citizenry here, so it's this is where you have to change your masks. Yeah? You have to change your personas. 1 minute you're a people, next minute you're a juror, next minute you're a citizen, next minute you're doing your civic duty. But all time, underneath all of this, you have your people mask on, because the people is essentially the land, and the land would be you know, named by whatever names their mum and dads give them, like the people themselves. So it's an interesting change of the face mask there. So you people are going to be grand jurors. You're going to judge citizens and see if these charges stick against citizens. You can interpret the legal accusations, even though you're not legally qualified to do so. And then it's up to you to determine whether or not the citizen that's being held to account is going to get punished or not punished.
I'm Leslie Stahl of 60 Minutes.
Buildings that have like incredible architecture and a shed ton of public money spent on them. Yeah, take that with a pinch of salt. Let's go to the main bit. Here we go.
Here you are, ready to begin your grand jury service. But many of you may be asking, what is a grand jury anyway? And how is it different from a trial jury? Well, those are really good questions.
Yes, little distinctions there. You have a grand jury, and you have a trial jury, which is actually used to actually have to be trial by jury. A jury trial and a trial by jury are apparently two distinct different things, but they sound the same, and they might confuse you with that. So you wish to have a trial by jury, trial by battle, trial by ordeal. Yeah. If someone says, "Oh, we're going to give you a jury trial," no, I want a trial by jury. And these tiny little word plays are all the things that you have to watch out for, because these can slip up and make you lose jurisdiction.
And here's a simple, brief answer. A grand jury decides whether or not a person should be formally accused of a crime. If that decision is yes, the grand jury issues what's known as an indictment. An indictment is a grand jury's formal written accusation of a crime. A grand jury does not decide whether the accused is guilty or not guilty. That's the job of a trial jury. There are other important differences between a grand jury and a trial jury. For example, the burden of proof. A grand jury determines whether there is legally sufficient evidence and reasonable cause to believe that a person committed an offense, whereas a trial jury determines whether the prosecution has proved the accused guilty beyond a reasonable doubt.
Okay, this is important. This is the word that Carl Lentz has always said. You've got to be careful about the word reasonable, yeah? Because reason is like beauty. It's in the eye of the beholder. It depends who is there at that particular time. It's what I call it, subjective. So subjective things are very variable from one person to the next, one individual to the next, one man to the next, whatever it may be, making the decision. So what they're saying here is like the grand jury look at it, see if the evidence matches up, is there reasonable grounds to do it, and then they all raise their hand up and decide whether or not it's going to go ahead to an indictment. Once the indictment is there, then the game's on and people are summoned into court to answer for the charges. Now the trial jury here, the trial jury or the trial by jury is the petit jury, the small jury of 12. And now they are burdened with beyond reasonable doubt. So it has to be definitive, it has to be absolute, that, like based on the facts here, mate, there's no way that you didn't do it. It's pretty tough in one respect to actually get to that point. But such is the burden of proof on the prosecutor that they have to be sure that when you're bringing up these kind of cases against citizens, or maybe in some case people who've done wrong, then you have to be, people's freedoms on the line, and that's why it is so stringent in that respect. It's not like a civil trial.
A grand jury proceeding is also different from a jury trial because a grand jury typically hears only from the prosecutor and the prosecutor's witnesses. But there's one thing about grand jury and trial jury service that's the same. You must not read or listen to news stories about the case, and you must not use the internet to search for information about the case, the lawyers, or any individuals involved in the case.
Absolutely, and this is sometimes what judges people get frustrated at judges with. Yeah, they cannot look at anything that was going to morph their view of the case. The prosecutor, it's their case. They come in. If they omit or forget to put things in that are obvious and they're out there, it's not for you to go out there and research it. It's for the prosecutor. You're not there to help the prosecutor's case. You're there to listen to everything that he provides you. If the prosecutor forgets to put something in, that's the prosecutor's fault. His case is going to fail. Okay, so that's the crucial thing, is that no one's here to help the prosecutor. The prosecutor is responsible for his own case, be it poorly organised or the most beautiful organised watertight case in history.
Your decisions must be based only on the evidence presented in the grand jury room. Now, I'm here to give all of you an idea of what you'll be doing as a grand juror. And by the way, I think you'll find it a fascinating experience. First of all, each of you will receive a copy of Article 190 of the Criminal Procedure Law, which governs grand jury proceedings. This is the legal framework. But let's take a brief look at how the whole system operates. In most instances, the process starts when a person is arrested, though there may be occasions when a grand jury is asked to consider an indictment before an arrest. Now, that's where your work begins.
Yeah, so you've got police. It can be arrested first, then they're indicted. Because obviously the police have to respond to breaches of the peace, or anyone can respond to breach of the peace as long as you're competent to manage it. But anyone can respond to the breach of peace. Typically it's someone who's sworn to serve the state in such a manner. And of course private prosecutions, or as it used to be in the records that I've been going through, is that you would approach a court and you wish to indict someone. You would need the relevant evidence, the relevant witnesses in order to do it. But essentially you can bring indictment because the state and the court system is not owned by anyone in particular, it's open to all. So, you can bring a prosecution yourself, as it was, or you can ask for the state prosecutor to help you because you're not proficient in these legal procedures.
When you begin your service, you'll be brought into a grand jury room much like this. The configuration of the grand jury room may vary from county to county. As you can see, there are 23 of you, a number established in English common law centuries ago.
So 23 is the tipping point again. So once you've got 12, there's only 11 people left. So 12 and 12 is 24. So therefore, once you get to 12, you've got your tipping point, and therefore, let's go ahead with it. Now, the important thing that I just want to go back and look at this. Okay, this is your grand jury room. Okay, it's a room which is normally aside to the courtroom. And the whole point of that is that it's a private room. People can go in and utter the wrongdoings, whatever it is. Right? Think of a wrong, and this might be something to look at with the Cliff Richard case, where he was accused of so many weird and wonderful accusations, and they were all public. I think the press were there before some other people were there. The police were there at his house raiding it. The press were just there as quickly as the police, telling the world all about these accusations. But this is the whole point of a private grand jury chamber, is that you're respecting the privacy of the accused and their reputation. So whoever comes in with this accusation is not going into an open courtroom. They're going into a courtroom to the side of the public courtroom, which is private, quiet, and respects the privacy of anyone who's accused. The reason you do that is because obviously if you're coming out of a trumped up charge or nonsense, or someone who's got a history of reporting rapes or whatever, someone who's obviously not of sound mind has each and every much as right as you do to report a crime, but it has to be handled in a discretionary way. If they haven't, it may well have happened. It may well have happened, but if there's not enough evidence to convict or actually have a case, then even though everyone here in the room believes you, there's no witnesses, there's no evidence, it's your word against him. You're going to need more than that, darling. We all believe you here, we'd all like to indict him, but we can't indict him because the evidence isn't there. Okay, so that's basically what it is. So it's not whether they're it's a good case or a bad case in some cases. They may all believe them, but at the end of the day, they're there to ensure that the due process of law, I suppose they'd say in America, is followed. And this is something that I just want to bring to the attention of the UK side, or the English side of it, is that in England they got rid of, since they got rid of the Court of Sessions and the Assizes, I think they were called, Assizes, sorry, my Latin is ghastly. So it was very much the case that John Doe would be able to get indictments done against wrongdoers, you and I, ordinary folk, because I've seen the records, but obviously you're approaching the government, the state, the body politic, the powers that be, in order to take hold of your prosecution, in order to indict a man, to have him answer for his breaches of the peace, or torts, or wrongdoings, or trespasses, I suppose you could use as another word. And in England, since they reformed the court system, now this is obviously, you can see, look, these are 25 people or 23 people being taken out of their ordinary day-to-day work. It is an inconvenience to people's lives. It's an inconvenience to business. It's very clumsy, and therefore you can see the administration of this is annoying. I'll put it that way, but it is obviously necessary. But in the same way, people don't want to do it. I mean, I could just escape here and say, look, my traumatic jury duty experience, and there'll probably be something else here saying, how the hell do I get out of jury duty when I'm summoned, and all this kind of stuff. There's all kinds of people on YouTube here. Yeah, look, how to get out of jury. It's just, people like, and all I would say to that is, if you're you know, a person of good conscience, and you don't do your jury duty when you're summoned to do it, then, or you want to get out of it, you want to somehow, you know, fudge it and not have to do it, then someone else is going to take your place, and that someone else may be someone who wouldn't have been as critical to the charges are there, or maybe someone who just wanted to say, no bill, not guilty, get out of here as quick as possible. I'm not saying that will happen, but the possibility exists. And in England, since they reformed all this stuff, we have no access to this procedure. There is no administration of a grand jury, which, you know, you might think, hey, that's crazy. But, you know, in one vein, I kind of see the logic behind it because of the inconvenience and clumsy nature of running the grand jury service for indictments. And so what did they decide to do? They, because this is within their system, they decided, right, what we're going to do, we're going to get rid of grand juries. And it's like, okay. And what do you propose to do instead? So it appears from what I've been reading is that instead of having these grand jury rooms to the side of the courthouse, we now have Crown Court judges there's one guy who's seated, who's sworn as a judge, is expected to act in an impartial and fair way. So if an indictment is handed to a seated judge, or has come made or brought to his attention, shall we say, then he's supposed to see the merits, the strengths or the weaknesses of it, the merits of the case. Now the problem I've got is that a seated judge or a judge would normally or usually be in the courtroom, just adjacent to, or just through that doorway there, if you like. That could be the courtroom there. And so, if you're going to go in front of a judge in England, this is why it's not made clear to the people. It's like the people would know how I demand to speak to the grand jury. I demand to speak to these people, because you don't need to be legally qualified to approach these people. These people are your fellow people. They're just as dumb as you are, or just as clever as you are. You know, these are just people with their opinions. So if I want to go in there and say, yeah, some guy stole my car, and I've got 2 witnesses that have done it, seen the guy do it, you know, there we go. But now I have to, instead, in England, we can't have access to this. We have to put all of these eggs into one basket, which is the seated judge, who essentially is a judiciary member, who are seen to be, is their words, seen to be independent of the government, and they are supposed to be seated there with no kind of fear of any decisions that they make, whether it's for the government or against the government. They're there just to be an umpire. So if you and I have to now, instead of going into a room like this, we have to go to open court, which is a public setting, where we wouldn't have the privacy afforded to these people in New York State in relation to indictments. You can see how this is all. Hang on a minute. So I don't have the privacy. I've got to utter it in the open in front of a judge who's being paid by the government, who I pray is going to be impartial and fair when he hears what I've got to say. Then that's interesting, yeah. You see, because if the judge is there and you're complaining about a policeman, a politician, a doctor, or whoever, okay, he's part of the same kind of system of government, but these people here are not, and that's the crucial difference. In a private room where they can hear it, you can discuss it. No one's allowed in, and they'll discuss that a bit more in just a second.
3 of you, a number established in English common law centuries ago. The court will choose your foreperson and assistant foreperson. You will choose your recording secretary.
So that's a foreperson. Always used to be a foreman of the jury. Always used to be a man, a qualified juror. Used to be like freeholders, man, people who had established themselves. Because the traditional forms of common law and the unwritten law is that you've got the written law, which is fantastic, and you have the unwritten law, which is built on like developed, tested wisdoms, if you like, from wisdoms of growing up. Things like experiencing bankruptcy, experiencing profitability for a company. All these dirty and nitpicky kind of experiences that you have in your life build a character. You build experience. You build knowledge. You build wisdom. And that's essentially what the grand jury is about. It's about being people who have been there, done it, seen the wrongs, see the rights, and they're kind of like, they've got families. They know all about parenting. They're kind of like broad-minded people, if you like. But obviously here is just a cross-section of society nowadays. So it's like I'll get onto that later, but obviously the jury pool has become quite deep nowadays as opposed to shallow.
A stenographer will be present to record the testimony and instructions, the official record. Once you're seated and sworn in, the prosecutor will arrive to begin presenting the first case to you, a presentation that will set forth the evidence against an alleged offender.
Good morning. I'm an assistant district attorney in New York County. I'm here this morning to present the case of the people against John Doe.
So she's used the classic example of John Doe. So she's bringing it on behalf of the people, all right? So this is the state, the people, bringing it on behalf of them. This person's representing the them, the they, the state, whoever that is, and is bringing it against John Doe. So you've now got the corporate body politic, the state as a whole, bringing it against the individual. That individual would presumably be a member of this organisation that's bringing them to, trying to bring them to be held to account.
At the conclusion of the presentation, I will ask you to vote on one count of robbery in the first degree. You will hear evidence this morning from...
The presentations you'll hear from an assistant district attorney may include homicide, robbery, grand larceny, narcotics crimes, possession of stolen property, rape, sodomy, assault, arson, kidnapping, burglary, possession of weapons, practically the whole spectrum of the criminal law.
Yeah, so you've got, and then within that criminal law, you have the unwritten law and you have the codified law, the statute law. You know, it's all there together. So yes, there's common law elements or law of the land elements, but it's all being mixed in with statute legislation. So you've got like the layman's laws with the codified laws, and this system takes into account all of them. But the way that this system works, to me, is very obvious that it's based within a legal framework. So this is a legally set up and defined process. So even though there are laws in there that are common laws, like unwritten laws, they're all mixed up together in a process that would make it very hard for any of these lay people sitting on the grand jury to actually get their head round how the system works, how to interact with it, and how these laws and things are written when they're written in a foreign language known as legalese, well, an uncommon language called written legalese. Even though it looks like English, it smells like English, it writes like English, it spell checks like English, but it unfortunately is legalese, and it's not open for your interpretation without the appropriate qualifications.
This doesn't mean you'll necessarily hear these cases in your grand jury term. It simply means you could. The prosecutor will present the case, call witnesses, and instruct you on the law. You will note that no judge is present during grand jury proceedings. The entire presentation is handled by the prosecutor.
Why is there no judge present? Because no one judges anyone in this land. You have a jury pool of the people are judging you. This is essentially why it's the people versus some weirdo, yeah? So I suppose you could turn it around and say that actually all these grand jurors are the prosecutors, because it's the people. This is a cross-section of the people versus John Doe. And what this is, the public prosecutor is the representative of the people, the state, and the state includes these grand jurors here who are going to listen to the prosecutor's claims and decide whether or not to go ahead with it.
Judge who oversees the grand jury.
And of course the judge is not a judge. Judge is just a magistrate to ensure that certain protocols of court for a fair trial. He's an umpire, You don't need to know, you don't need to be an expert to be an umpire. Like a boxing umpire. He just knows no below the belt, no back of the head, obey my commands at all times, no punching when they fall down. I count to 10 when they're, anyone can kind of get a grip of the rules of boxing. We've all had experiences of it. Obviously there will be small minutiae of rules of boxing that we may not be aware of, but how long will it take for you to sit down and be told what they are? So the job of the judge is just to ensure a fair trial is established and maintained.
Is available should the need arise. Most presentations take only a short time, although some cases might run for several days or more.
Yes, sir.
Was it light enough inside the building for the victim to take a good look at the man that attacked her?
I'll have the witness come back in and ask her that question.
If you have questions for a witness or questions about the law or about the evidence, you may ask these questions of the prosecutor during the presentation, or you may ask to speak to a judge. The prosecutors and judges are your legal advisors.
Yeah, they're your legal advisors because they know that you can't interpret legal nonsense. But that guy hasn't asked a legal question. That guy was saying, look, did he actually see the person? Is there going to be any mistaken identity here? But now that was a lawful question. Did you get a good look at someone? When this guy gets cross-examined as a witness, if the witnesses have been cross-examined, these are the kind of questions that are going to pop up. So if she says, oh, it's pitch black, I didn't see a thing, then well, what's the point wasting the court's time by getting this case in with a witness that didn't even see if it's light or dark, couldn't see anything? Yeah, so but that's not a legal question, that's just a cross-examination.
And as you will read in Article 190, you are forbidden by law to seek or receive legal advice from any other source.
Can I just highlight the capital Y on the U? Because you, as the civic duty grand juror with duties and obligations, is the capital Y on the U.
You should also know that the accused person has a right to appear before the grand jury.
Absolutely the most important thing you do whenever you're indicted. Get your ass in front of these grand jurors.
On his or her own behalf. He or she may also ask the grand jury for permission to present other witnesses for the defense. But keep in mind that no accused person has a duty to appear or present witnesses and may not even know of the grand jury proceeding. As a result, it's very rare for an accused person to appear before a grand jury or present witnesses. And don't come to any conclusion, positive or negative, because the defendant does or does not appear. And perhaps this is a...
That's it. You don't have to be there. I'm not entirely sure when it is. I think it's when they found you guilty. You have to appear in person for the final ruling or the judgment or something. But that's when the defendant has to appear. Yep. So your attorney can go out, whoever you want to go. Your friend, whoever you trust to go out and represent you in a defense capacity. They can go out there with your best interests. But the prosecutor, they have to swear to the truth of the allegation. So they have to be there at the beginning in front of the grand jury where this whole process starts. So they have to swear to the truth of the matter. And then at any point, if the defendant wishes to cross-examine the person who's accusing, the accuser has to take the witness box and they have to answer the defendant's questions.
A good time to remind you that all grand jury proceedings are strictly secret.
This is crucial. It's what I was saying earlier on. They have to be in secret because you can't libel people. You can't slander people's good name. You can't defame people. Yeah, hey, Barack Obama, blah blah blah, this, or Donald Trump, da da da, this. These people have a job to do, and they've got a certain standing in society and certain reputation to uphold and keep. They don't want every Tom, Dick, and Harry who voted Democrat to say, oh yeah, he's a this, that, and the other, and I accuse him of this, that, and the other. And it's like, no. This will all be done in private. It won't be done in an open forum in a public courthouse. It'll be done. You'll have access to the people and their conscience, but you'll do it in a private room so that all what goes on behind closed doors stays behind closed doors until there's a justification to bring it into the public. Something that, like in the Cliff Richard case, was not respected. These journalists seem to be getting tipped off by cops and police officers. As to certain arrests of high-profile nature, for what you can only presume is for monetary gain, but who knows? I speculate.
Against the law to reveal anything about the cases presented to you, and there are good reasons for this.
That's it. It's a trust. Essentially, again, trust law comes into everything. This is a trust. Someone's coming in, trustor. They've got a case. They're putting it into the hands of the trustees for the benefit of the people or society as a whole. So the case is owned by the prosecutor. The prosecutor brings it in. The court system as a whole is the trustees of it. And I think everything comes into a triangle-shaped trust. Someone has something. Someone's going to look after something or perform something, look after something, and there's a beneficiary. There's some sort of benefit to someone or society as a whole.
This strict secrecy ensures that witnesses can cooperate fully.
That's a good point.
It encourages free and open deliberation among grand jurors,
Yep.
and it protects the innocent person who may be investigated but never indicted. But now, back to the proceedings.
According to New York penal law, Article 160.15, robbery in the first degree is a Class B felony.
Now you're talking code, all right? Spot the code. Hang on, you just said what to me? So they're speaking code to you. They're speaking Class 1B felony, whatever that was. Yeah, and you've got 25 or 23 people there, all like should be going, hang on, what did you just say? Sorry, are you speaking gibble-bobble? I think they call it gobbledygook down in America. Look up the word gobbledygook.
And it reads, a person is guilty of robbery in the first degree when he forcibly steals property, and when, in the course of the commission of the crime or of immediate flight therefrom.
Yeah, see, there's a lot of loopholes there you can pick apart. I mean, the commission. What, a commission of a crime? Who the fuck commissioned him?
After presenting witnesses, the prosecutor will explain to you what law the defendant is accused of violating. After that, the
Oh, we all like a bit of violation.
grand jury will deliberate in secret and decide if there's enough evidence to indict the defendant.
The crucial thing there being in secret, they will decide amongst themselves. So again, bring that back to the English system at the moment. We have an indictment go straight to the judge in front of you, who's seated in a public gallery, and he'll decide the strengths or merits of your case. This, from an administrative point of view, is fantastic, but I have concerns about the just the administration of it in practicality, with the human nature as a variable in that equation.
He or another participant in the crime causes serious physical injury to any person who is not a participant in the crime. That concludes the presentation of the evidence in this case. We're going to step outside
And then you'll be left alone to deliberate and vote. The law requires at least 16 of you to be present to make a quorum. Of the 16, a vote of 12 or more who have heard the evidence is required for an indictment. If in your deliberations you vote yes for an indictment, this means the defendant has now been formally accused by the people of the state of New York.
Yeah, and the capitalization here again is crucial, because this is dealing with people within the society that they're fighting against. It's very important because it's lowercase. The against is in lowercase. Defendant with a capital D. John Doe, fully capitalized. The people of the state of New York, waived. I don't know what that means up there, but whatever. And then the indictment. So all of that means something. So that when it's fully capitalized, these are things that we have ownership and control over. Against is obviously just the word against, and or versus is sometimes used, or v, and then the defendant as a job to do, as defined by the court.
This case will go to a trial court where the defendant may exercise his or her right to a jury trial. And it
His or her right to a jury trial? I think you mean to say his or her right to a trial by jury. Very important.
will be up to that jury, the trial jury, to decide guilt or non-guilt. If you do not vote for an indictment, then the charges you heard against the accused are dismissed.
So dismissed being, take him away for today, come back another day when you have a better case.
The end of that particular case. You should also know that as a grand jury, in addition to your vote on an indictment, you also have the authority in some cases to direct the filing of criminal charges to a local criminal court, or send the case to family court, or submit a report on issues concerning the public interest.
Yeah, whatever that means.
The prosecutor will inform you when it's appropriate to consider one of these actions. And that's it.
That's it. Of course, the prosecutor will direct you to direct the court to move to a family court or another location in order to secure the best outcome for their case.
Now then, how important is your decision? Well, look at it this way. Accusing a person of a crime is serious business. It is you
She just said it there. It's serious business. This is all business.
collectively who decide whether or not to make this formal accusation. As grand jurors, you're a cross-section of the community. And as such, you are serving as an arm of the court, not as an agent of the police or the prosecutor. It's essential for you to be attentive and fair-minded in hearing cases and in your deliberations, because you and your decisions are part of the foundation of the criminal justice system here in New York State.
Okay, that actually was a nice way of summing it up. So what they're saying is, with all the power of the state, with all the guns, with all the police, with all the agents who have, you know, ATF and CIA and all, I don't know, whatever else you can think of, it's like this system in place here is designed to keep the checks and balances of a government going out of control, and that's been well recorded in England, where kings have tried to have certain opposition opponents put in the Tower of London or had their head chopped off. And I'm sure it's the same in America. I'm sure there's cases of that going on. But that's essentially why they've enshrined this body of justice to run in accordance to these procedures, so that at least the people themselves have a responsibility to ensure that all things are morally correct. Yeah, never mind the legally correct, never mind like the influences upon society and stuff like that. It doesn't matter what the outside macro, if you like. Let's look at the actual case in front of us, and let's get these 25 people or 23, whatever way you want to look at it, people inside, just to sum up based on their conscience. And that's why qualifying the grand jury is so important. It didn't even touch on it here. These are just people, oh, we just summoned these guys in. Well, who are these guys? Oh, they're just some guys. You know what I mean? We picked them, don't worry, they're fine. So this is why you have the rights to qualify the grand jury, so that you can check all of these people and say, why is that? Like, for example, you might say, hey, why is this white woman here? Why is she there? You know, think of the O.J. Simpson case. People complain about all the black people on the jury, and people might know, well, you shouldn't really know O.J. Simpson, but, you know, you at least want people of your, similar standing. You know, neighbours is sometimes, you know, you want your neighbourhood to come and judge you. You want the people who have a similar outlook on life, a similar social standing to you. That's what peers is referred to, judged by your peers. Now, people aren't peers. Peers is a class of nobility. So peers and nobility would be like the barons would judge the barons. Yeah, you wouldn't have the king judging the barons, and again, so on and so. You wouldn't have a baron judging the king as such, but you know, obviously the barons got together as the muscle and put certain controls over the divine right of the king. But here, in the grand jury sense, you know, who are these people? How did they end up in front of this grand jury? This is the grand jury stage, but essentially, specifically for the trial jury, they're the people that you have to nail, or the trial by jury. God, I'm mincing my words here. So the trial by jury is when you have the opportunity to kind of nail who exactly is going to be judging you in the case. So that's what I see it. I see it as a barrier between the power of the state, whoever like, let's say, so put that in terms that we can understand. So these 23 people are the barrier to, like, a Donald Trump, for example. They are the barrier to a Barack Obama. It's a barrier to George Bush's. Yeah, it's a barrier to some sort of overpowering state or national force against that could be misused against the individual people, yeah, or the individual citizen in some respects. So that's all it's for. And I think this presentation is pretty good in terms of defining that. So it stops the state from doing things like what you might say in England recently, big like things like what happened to Count Dankular with his silly joke that he published on the internet. Yeah. So if that went before a grand jury, or if they had to indict him in front of a grand jury for that criminal matter or crime, then the jury might have said, yeah, okay, it's a fantastic observation, but it's not something that we really want to take up court's time for, because he's just a stupid idiot, and we can all see that, and the grand jury doesn't think that we want to waste any court's time with someone who's doing a stupid joke. And that is where context, there we are, there's an answer for Dankular. This is why context didn't matter in his case, because did he say the words, yes, did it meet this criteria for the crime, yes, you're guilty, my friend, of the crime. And that's why context is determined by the court and the judge, because they're writing the rules, and the grand jury is the only thing that is going to apply common sense to such a nonsense pug joke, whatever it was that he did at that time. And there's probably loads of other things as well that I could go through if I wanted to, but let's try and keep this video from running too long.
these all across
this
the
guy.
state of New York. Grand juries such as yours will hear some 35,000 presentations or cases. Grand jury presentations range from the 9,000 or so each year in the most populated counties of New York City to less than 100 in smaller counties. To keep this vast justice system moving swiftly, fairly, and efficiently requires a dedicated corps of judges, attorneys, court administrators, and grand jurors just like you. I'm Jonathan Lippman, Chief Judge of the State of New York. More than a decade ago, the court system launched a comprehensive program of jury reform. I'd like to share some of the improvements with you.
So how do these improvements compare to the improvements that were laid upon the criminal justice system in England? So I've already explained them to you. The grand jury was removed, the administration was removed, and it is now essentially gone to one trial judge who will literally see the facts, see the evidence. Because I like to believe in these people because they are independent of the government. They should be independently minded. They should be free to make their own decisions based on the facts and the evidence. So in some respects, fantastic. No administration. You get a fair, impartial legal guy who knows exactly what's going on. He'll see any weaknesses in the case before like a normal person would, and it just speeds up the whole process. But obviously the one guy who sits as a judge, who's been legally trained, legally qualified, been a barrister for God knows, and is in with the legal, has a legal society oath, is now sitting as a judiciary member and has to put that oath on a back burner and put his judicial oath on that burner and think, right, let's say it's an indictment against a cop, or a cop has acted criminal, or Donald Trump or Tony Blair needs to be held to an account. He's like, you know what, I might just say not true bill this time. I don't think this is a indictable offence at this particular moment. It's all coming down to one person as opposed to 12 to 20, 25 or 23 normal Joe Blogs.
For one thing, we made the jury selection pool much broader and more inclusive.
I don't like that. I think that's a mistake. There has to be a certain amount of life experience, before you can go on a jury pool, in my experience. Not in my experience, in my opinion. All right, you have to have people who are experienced in life. I went into a trial by jury in Guildford Crown Court, and there was some guy there on the front bench wearing a Star Wars t-shirt, and that was a particularly sensitive case. And I was like, if I was being accused of anything, and I had a guy who turned up to court wearing a Star Wars Jedi t-shirt, being all casual in the courthouse, I would ask for him to be removed immediately. I said, this is outrageous. When you're being threatened with serious jail time, and you've got a guy turning up with a Star Wars t-shirt as a jury member, you put your hand up to the judge and say, look, this is not on.
Persons from all occupations and income levels are now expected to serve. This rich mix of all segments of our society is our best guarantee of a truly diverse and representative grand jury.
That word diversity again, you've got to be careful about diversity. And a lot of the people who do YouTube videos about the grand jury service, they're not much more than 18 years old, and some of them aren't. And I don't know what the benefit of calling up 18-year-olds are, impressionable people, to come and do their civil. In fact, there was someone in my college when I was 18, 19. They got called up for jury service. It's just like nuts. These people determining. It's not that I don't trust them. It's just that they probably don't know the law. They're just giving they're giving a gut instinct as opposed to knowing like the nuances of what's right and wrong, in terms of applying that to the law and what the importance of the grand jury is, and not about nailing people and putting them in prison, but it's about protecting individual rights against this.
Further, we have established convenient qualification procedures. Juror qualification questionnaires can now be completed online or via telephone. Today, jurors are summoned less often, and jurors who serve more than 10 days are excused from service, entitled to one automatic postponement online. We've created a grand juror's handbook, a hand-concerted effort to provide. And with your help, could be improved. Everything in our power to make your grand jury experience as satisfying and rewarding as we possibly can.
Yeah, you see how that was? That was almost like a businessman who's got like, you know, imagine as it like this. You've got like a corporation, a business making money, right? And now within their corporation, they're mandated to have this system in place where the people have to come forth in order to exercise your judicial will, or your criminal laws rely on the agreement of lay people who come in to represent your society. So they really are pleading with you to understand the system, to work with them in such a way that allows their system of government, of state administration, to proceed in a fair and honest way. They're really pleading with you here.
In return, we ask you to bring to your grand jury duties a true sense of involvement and dedication. Your mission is twofold, really. On the one hand, to use your power as grand jurors to investigate crimes and hand up an indictment when sufficient evidence exists to do so. On the other, when the evidence is insufficient, to protect people from criminal accusations.
Protect people here, not defendants, not citizens, yeah, not the accused, not prisoners, people.
By not handing up an indictment. Without your commitment, our system simply doesn't work.
Our system.
But working together, we will continue
working together. We've got to work together. This is a cooperation in business, my friends.
To ensure for all of us our most basic American heritage, justice for all. Thank you for your time and for your good service.
And I think we'll call it a day there. But there we go. So that's where we are. So how would this have helped? So, in summary, I look at things like the Grenfell Fire, right? So let's look at the Grenfell Fire. If you don't know what that is, just Google Grenfell Fire, and you'll find out all about it. But this is where grand jury indictments for like criminal manslaughter, or I mean, I don't know what the legal charge would be. You'd have to get legal advice for that. But you know, essentially killing. Yeah, someone's died, someone's been killed, and now you need to bring some sort of charge against someone. So in a criminal context, you know, the families of Grenfell Tower would run into wherever the grand jury was being held in their local area, which presumably would have been Nottingham Crown Court or Magistrates Court. And there they would go in and say, oh, you never guess what's happened. The tower's burnt down and we believe 70 plus people have died. And these are all the families. We've got about 100 witnesses, maybe more, a lot of it video recorded. And we believe that this building was being administrated by the council. So essentially, that's how that would work. You know, you'd have all these different parties would come together, and you probably, in this case, it'd make more sense to have, I think Americans call it a class action suit. So you'd have some sort of prosecutor would come forward. Now this is what's lacking in England. Where is our public prosecutor? Where is this state person, the state attorney or the state prosecutor, or the, you know, think how many lawyers and barristers there are in England. Why has not one lawyer or barrister come forward and put a criminal investigation? Justice delayed is justice denied. We're over a year and a bit past the time of Grenfell. It doesn't require a massive, what are they doing at the moment? Inquiry as to what the facts and evidence. That's for the government's purpose. It's not for a justice purpose. That inquiry is for the government to learn from its mistakes. It's not for holding people to account. People being held to account will come when someone opens a court and takes someone to charges someone with an indictment or an information or some sort of thing like that. That's not going to move. So there needs to be some sort of prosecutor that comes forth who is legally competent to hold and administrate the court system in the criminal justice system. Bring all these people as the, you know, it'll be you could do some sort, you know, it could be like the Queen versus such and such. You could do the Queen versus Kingston Borough Council. Is it? No, Kensington and Chelsea Borough Council, I suppose that would be. And then obviously you would have the head of the time could be liable to come up and answer for his crimes. That would be a criminal charge against the person of the corporation, or you could have the criminal charge against the individual at the time who was in charge of making all these decisions. Sorry. So that's, I mean, I'm not legally qualified, but I'm just giving a broad outline of how it would work based on this American video that's just been shown to us. So then obviously the prosecutor, wherever this mysterious person in the whole of 70 million people in the UK, whichever one of these lovely honourable people would step forward to represent the interests of some lowly people, poor people of Grenfell, would say, right, I'm going to take all your witness evidence, going to make a really good case for you, I'm going to present it on an indictment or an information to wherever the procedure is that they have within the legal society and the legal system of criminality. And then once they've got that, then people have a case to answer for. People can be summoned in, the witnesses can be taken. But at the moment with the indictment, it looks like a trial, it smells like a trial, but it isn't a trial, it's just a fact-finding exercise. That's the main difference between what's going on. And this is the weakness of the grand jury, is the fact that a normal man cannot come running in front of a grand jury and plead his case. He has to do it through an interpreter. And that's what's happening in the UK. That's why no criminal charges have been brought up, because until the cometh the hour, cometh the interpreter, the legal person who's qualified in criminal law. So think of every single criminal lawyer up the country, not one of them's decided to get off their butt and say, right, Grenfell, let's do this. Because why would they do that? Because they're holding their own society to account. And that's not going to happen, is it?